So how much longer does the Republic have? 230 years ago, the founders scripted a basic compact of limited, enumerated federal government and unalienable, some sites inalienable, fundamental rights. Having forged a new republic of separate states, capital S, united, little u, to ensure domestic tranquility, provide for the common defense, promote, not provide, notice the difference, the general welfare, and secure the blessings of liberty. Rights that they had witnessed abused, abridged, infringed, and abrogated by the Imperial British Crown. There were opposing factions. Some wanted a bigger, more encompassing federal government structure. Some wanted a smaller central government. Compromises were made, but there were numerous items that all the signatories could agree on. The Bill of Rights was born out of a need to guarantee that this newly authored rule of law could never again be used to subjugate, enslave, or abuse its privilege. It was begun in 1865 after a brutal, antagonistic, and illegal war on a free people whose only wish was they be left alone to govern themselves in the manner they were once guaranteed under that same Constitution. Since then, the American political machine, controlled by banking and special interests as opposed to the rule of law, has most excellently applied Marx's 10 planks. And let's take a look. Number 1, the abolition of private property and application of all rents of land to public purposes. This has been successfully applied by the rubric of eminent domain under the 14th Amendment. A heavily progressive or graduated income tax. That comes from the 16th Amendment. Abolition of all rights of inheritance, which has been exercised in the federal estate tax of 1916. Confiscation of the property of all immigrants and rebels, Executive Order 11490, Section 1205, and the 1997 Crime and Terrorist Bill. Number 5, centralization of credit in the hands of the state by means of a national bank with state capital and an exclusive monopoly over the same. Federal Reserve Act of 1913. Centralization of means of communication and transportation at the hands of the state. Federal Highway Act of 1916, Communications Act of 1934. Interstate Commerce Commission given authority by Congress to regulate trucking and carriers on inland waterways, 1935 through 1940. Number 7, the extension of factories and instruments of production owned by the state, the bringing into cultivation of wastelands and improvement of the soil, generally in accordance with the common plan. The Desert Entry Act and the Department of Agriculture, as well as the Department of Commerce and Labor, Department of the Interior, the Environmental Protection Agency, the Bureau of Land Management, the Bureau of Reclamation, the Bureau of Mines, National Park Service, the Agricultural Adjustment Act of 1933, paying farmers not to plant. Number 8, equal liability of all to labor. Establishment of industrial armies, especially for agriculture. The Social Security Administration and the Department of Labor. The 19th Amendment and the Civil Rights Act of 1964. Unions, affirmative action, Federal Public Works Program, and Executive Order 11,000. Number 9, the combination of agriculture with manufacturing industries. Gradual abolition of the distinction between town and country by a more equitable distribution of the population over the country. The Planning and Reorganization Act of 1949, Executive Orders 11647 and 11731. Number 10, and this is the one that bugs me quite possibly the most, free education for all children in government schools. Abolition of children's factory labor in its present form, combination of education with industrial production. The Department of Education, the NEA, and outcome-based education. Under the auspices of national security, the President has secured almost unlimited and unchecked powers using executive order. Congress approved the passage of the War Powers Act in 1933, which gave Franklin Delano Roosevelt the presumed authority to act swiftly and decisively to prevent extended damage and demoralization from the Great Depression. He swore that once they were no longer necessary, he would return such powers from the office to the legislature. 76 years later, presidents still enact unconstitutional mandates and executive legislation, citing the Patriot Act as one, in direct defiance of constitutional law. What is worse is Congress and even the Supreme Court permit this despotism. That Congress had the audacity, the arrogance to enact such blatant, spurious legislation, illegally delegating the authority vested in them and left alone to them by we the people, to the executive offices in and of itself is an act of, if not questionable ethics, criminal enterprise. The Second Amendment very clearly lays out the course for men of faith, men of reason, and the rule of law to defend the pre-purposed design of the Constitution. As the Constitution was written to define, describe, and enumerate the limited and only powers that the federal government may make use of, it is implied and provided explicitly by the 9th and 10th Amendments that all other powers are reserved to the individual states and, barring their effect thereon, to the people. Truly, then, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The militia of the people is recognized as the single defining and controlling body of the rule of law to prevent the egregious and invasive forms of centralized, paramilitarized federal interference into the lives of sovereign citizens. Being that the Constitution was formed and ratified by the people are then the ultimate authority on their destinies. Such does not meet with the approval of the government in place today. There has been a steady and precipitous decline in individual rights and a vast increase in federally mandated appointments, apportionments, taxes, and jurisdictions, which the founders would never have permitted, lest they would have included them in the founding documents. Any number of federal agencies presently operate extra-constitutionally. That means they operate outside the rule of law and without any constitutional basis for existence. In fact, many of them operate in direct contradiction and defiance of their constitutional directives. The Internal Revenue Service, the Bureau of Alcohol, Tobacco, and Firearms, a violation of the Second Amendment. The Department of Education, violation of the 9th and 10th Amendments. Department of Homeland Security, Federal Emergency Management Agency, or FEMA. The Environmental Protection Agency, Federal Communications Commission, direct violation of the First Amendment. Occupational Safety and Health Administration, NASA, the Federal Bureau of Investigation, which is a nationalized police force, the Drug Enforcement Agency, Transportation Safety Administration, the Food and Drug Administration. I could go on and on with what the general population may consider to call alphabet agencies. And then I could cite thousands of violations each one has made against the liberty of independent sovereigns in this country. One need look no further than the sieges at Waco and Ruby Ridge for evidence of the ability and the determination of the federal government to force its will on the people, to coldly and callously murder innocent men, women, and children whose only transgression was the imagined crime of rejecting the spurious and invasive policies of the federal Leviathan. Before I go any further, I have to take a moment to provide us a safety net, a caveat that protects and indemnifies each and every one of us from suspicion of insurrection or rebellion, which are clearly defined under the constitutional laws. While the militia of the people is recognized and provided for by both the federal and state constitutions,